Good evening. We'll ask the Zoning Board of Appeals to come to order. And we'll ask the members to introduce themselves, starting on my right.
Roger Loja.
Beth Sear.
Sean Shoemaker.
John Tufts.
Dwayne Woodson.
Mark Sear.
Already started. The purpose of the hearing is to review the administration appeal of Gene and Sally Warren. The applicant has appealed the decision of the code enforcement officer in denying a building permit. And the board needs to determine if we have jurisdiction, which the only thing is that was the appeal filed within the right time, or within time limits, and I believe it was. Any discussion about whether we have the jurisdiction? We do. We would at this time ask the Moorings to come to the podium and speak their case.
Good afternoon, ladies and gentlemen. My name is Tim Dietz. I'm an attorney at NATO and Associates, an associate attorney there. I'm also a trial attorney at that firm. I have been invited here by Gene and Sally Warren to speak on their behalf with respect to this Zoning Board of Appeals appeal that they have now before you regarding their application for a building permit for property that they own here in Waterboro, and which was subsequently denied by the code enforcement officer. I'll certainly entertain any questions that you might have. You have the material, you have the appeal in front of you, so, and I'm assuming that you've read that, but I can go through the material if you'd like me to. But I think what we can do is just basically sum this up, that we believe, and the Moorings believe, that they have access to the property under any of three alternative theories for getting access to the property, and that's the basis for our request that you find that the code enforcement officer's denial of the building permit was in error. The first alternative theory of access to the property is that Bus Lane Road, which runs across SAD 57's property adjacent to where the Moorings have their property, is a public way. And it's a public way under two theories. One is that the school is either dedicated a public way or its use has established, not through adverse possession, but that it has become a public way by the evidence shown that they have opened it up to the public. Without digressing into other issues here, I do note, and I believe that it's in your briefs that you have in front of you, that the school district has sought to selectively enforce an effort to keep the Moorings off of school property while they let the rest of the public at large onto the school property, which is why we're saying that there's a public way there. That's also why there's a dedication to public use, is that the property is open at all times to the public to use. You've got some photos in there that we've provided for you that show cars from the general public parking in that area. There's a parking way. They park on both sides of Bus Lane Road. In addition to that, there have been comments made to the Moorings by Waterboro officials to the effect that this is a public road, or that you have access to this. In fact, there was a requirement in anticipation that a building permit would be granted to the Moorings. In anticipation of that, they were required to get 3 surveys done to put a septic system in on that property. And that was done in June or July of this year. And that was done at quite a considerable expense to the Moorings. So because of that, we're saying our position is that there is a public way there, that town officials are stopped from denying that there's a public way there, as is the school district. The third alternative theory for finding that they have access to the public is, or that they have access to the property, is through what's called adverse possession. Now, we know that we can't get adverse possession over government-owned property. That's not the issue here. But the issue is whether adverse possession had been established across either Bus Lane Road or even in the alternative Ricker Lane for the requisite 20 years prior to SAD 57's acquisition of the property in 1968 and 1973. And if there is adverse possession based on that theory, then the Moorings, in fact, do have access to the property. The basis for the denial of the building permit from the code enforcement officer was because there was a judgment that came out in 2005 that said they don't have access to the property through a private easement over Bus Lane Road or any other access to the property. What was not before the court, and what you have in the brief in front of you, is that the court did not decide whether there was a public easement or a public way or other public access to the property that the Morans now own. The only thing that the court decided was whether there was a private easement, not a public easement. And that's the basis for our request that you find that the code enforcement officer's denial of access to the, or denial of the building permit on the basis of no access to the property is in error. And that's because there was the wrong law that was decided in that case. What was not before the court, which the code enforcement officer apparently did not consider, was that there is a public access to the property. Thank you for your time. I'll answer any questions that you have. And I assume that, I understand there's an attorney for the school district here, which I assume is going to have a counter argument.
Any questions?
Yeah. This time.
We got a little-
Not this time.
Okay. Again, I thank you for your time, and if you have any questions that come back up, I'll certainly be happy to come back up here.
Patty?
Yeah.
What?
I just very briefly want to say that based on those three arguments or points that were made, I don't feel it's within my authority to determine what is a public way. It is not a public road within the town of Waterboro as far as us maintaining it and owning it, the town doing that. So I don't think it's within my authority as code enforcement officer to determine whether someone has a public right to use a private road. Also, adverse possession is beyond my authority to determine as well, I believe. And building permit applications require 3 septic designs for me to even consider reviewing it. That in no way guarantees the issuance of a building permit. It's a requirement that everyone has to give in order, with their building permit application. They have to show that there's that the lot will support a septic system. And based on this court ruling, it looks like there isn't a private right-of-way, so I had to deny the permit because of that reason. And really, I think that's my argument.
Okay. Natalie?
Good evening, board members. My name's Natalie Burns. I'm from Jensen, Baird, Gardner, and Henry. I'm here this evening representing Code Enforcement Officer Patty Berry because Patty has consulted with our office a few times about this issue over the years. And just to give you a little bit of history, there was some reference to the fact that Patty did require some septic designs. And until there was a court case, the town's position on this was, as long as there was some claim that there was a right to utilize the Bus Lane Road or some other easement, the town would issue a permit. But we now know that there is no legal right to utilize the Bus Lane Road because there has been a court judgment to that effect. I briefly want to address the question of whether Bus Lane Road is now a public way that everyone can now use, including the Morans, as an access. First of all, under Maine law, there are, some of you may know this, and I apologize if I'm telling you something you already know, a public way or a town road is created one of 3 ways: through dedication, which also requires acceptance by the town meeting in the town of Waterboro, by public use over a period of years, or by laying out and taking, which again requires a town meeting action to establish where the way will be and how much damages will be paid to the abutting property owners for taking their land. Bus Lane Road is not a road that has ever been accepted or taken by any action by the municipal officers or by the town meeting in the town of Waterboro. So we know that it has not been created as a public road or a public way in that manner. So the only thing that would be left would be any kind of claim of public use. I think it's important for this board to know that the law court has addressed the issue of whether everything that is utilized by a municipality or a quasi-municipal entity or a school district necessarily becomes a town way. And there there's a court case, I brought a copy of it that I can share with the board, Town of Kittery versus McKenzie. It's a 2001 Maine case. And in that case, there was a claim by someone that they had a right to use the dump road in the town, and the dump road had been created through an easement, but it had never been accepted as a town road. And the people who were claiming they had a right to use it were also claiming the town had to maintain it as a full road, and the town said, well, no, we don't have to, because we acquired this road simply as an easement and not as a town way. And the law court agreed that just because something is utilized by the public does not necessarily make it a full town way. So I think it's important that the board know that there's that principle of law. But I think even more importantly for this board tonight, this board does not have the jurisdiction to determine the status of any way or road or easement within the town of Waterboro. You have to rely, if you have records in front of you that show that something's a town way, that's fine, you can rely on that. But someone can't come before this board and argue, oh, you should find that we have a private right-of-way or that we have a public right to utilize this, because Maine law is very clear about who has the legal authority to do that. It's found in Title 23 MRSA Section 3028, and that section, subsection 2 of that statute states that the determination of the status of a townway or public easement can be made in the first instance by the municipal officers. And of course, in this town, that's the Board of Selectmen. It's not the Board of Appeals. And that determination is binding on everyone until a court determination is made. Well, interestingly, in this case, you know a court determination has been made that there's no private easement. You have heard that the Morans have argued, well, that didn't determine whether there's a public right to utilize it. But I would argue before you that, in fact, it did make that determination, because the Morans needed to raise that argument in that court case. If you've read the case, you'll see that there was involved in that a claim of trespass that was brought by the SAD against the Morans. If this was a public way, the court could not have found that there was a trespass. You can't trespass on a public way. So I think necessarily that court involves an overall determination of all of the possible claims. The fact that the Morans didn't specifically argue that doesn't mean that that issue hasn't been decided in the context of that case. And I know the SAD has a lawyer here, and I suspect he'll want to address that issue at greater length. But in summary, our position on this is that the code enforcement officer, based upon the court case, had to deny the building permit because the application did not meet the requirements of the ordinance for access that are found in section 2.06 of the zoning ordinance. And if you have any questions, I'll be happy to answer them. Thank you.
Any questions yet?
No, at this time.
Okay.
No, sir.
Okay. Somebody else like to speak? Somebody else?
I'm here with the superintendent of MSAD 57, and my name's Brian Willing. I'm at the law firm of Drummond, Woodson, and McMahon, and I frankly won't take up more of your time re-arguing what your town attorney so eloquently argued. So maybe what I can do is add some context, and I'm hoping that you'll accept just a few background papers on some of this stuff. I was involved in the actual court case before the Superior Court in Alfred and have some perspective on that and some of the background to that. Very briefly, this matter has gone back between the SAD and the Morans for now, I think, going on 13 years. You'll find in the package of materials that I gave you multiple letters written by town code enforcement officers prior to today denying building permits for the Morans on, exactly the same arguments before the court case had even happened, let alone after. As a result of those denials, in which case different code enforcement officers found that that there was no right-of-way and therefore a building permit couldn't be granted. So that prompted the Morans to finally go to court to assert that they had an easement over the school bus lane, and that was litigated over a 2-year period and finally concluded, as you know, now I think, I want to say 3 years ago, 2 years ago. In that case, they asserted a private right-of-way, certainly. In large part, the basis for that private right-of-way was an argument that going back decades, there used to be power lines that ran in the vicinity of where the school bus lane was, and the Morans had argued at trial that people used to walk out there and snowmobile out there and do other things, and that had created a public and private right-of-way, because the Morans also claimed that they used to walk out there to the property they now own with their uncle, Mr. Smith, and Elva Smith, and pick blueberries, and that was sort of the basis of their claim, that had been what they'd used, that old power line easement, going back to 1964 when Russell Smith had married Elva Smith and owned all that property out there. Likewise, they argued that the use by the public of the bus lane also constituted an avenue for them to obtain access to their property. And as your town attorney so eloquently put it, the court found not only that that wasn't true, but found that they were trespassing. Now, there were no damages or anything. I think the court awarded nominal damages of about $5. But the court found that the use of the bus lane was a trespass, and by definition, you cannot trespass on a public way, obviously. I would also just like to give you a teeny bit more background. Attached to the materials I gave you is the deposition of Elva Smith. Elva Smith is Sally Moran's aunt and the wife of Russell Smith, and they were the predecessors entitled to the Morans with respect to that property. Elva and Russell owned all of that property out by Massabesic Junior High and Massabesic High, and all the property along Ricker Lane there that abuts it. And over time, they developed the property and sold off lots. By mistake or otherwise, nobody's clear, because Russell died back in 1984, long before the dispute erupted. Russell had conveyed out sort of the last piece. In that process, again, by accident or otherwise, he had managed to landlock this 1 5-acre parcel of property now owned by the Morans. Subsequent to his death, Elva, I think through word of mouth or otherwise, found out that she had now had this landlocked 5 acres back there. And so in 1994, when the Morans approached Elva about possibly buying this 5-acre lot, Elva told her, look, I've been discussing, conveying it over to the school district, because the fact of the matter is it's landlocked and you can't access it. And Sally said, and this is in the deposition transcript at page 8, and you can look at it. Elva told Sally, look, it's landlocked, and Sally said, don't worry about that, we'll take care of it. And if you follow along what happened after that, she tried to take care of it. She went to the town in 1995, tried to get a building permit. It was denied. Went to the town in 1999, tried to get a building permit. It was denied. Filed a lawsuit against the school district, went to trial, had a judge consider it, and the judge found no right to go there. Now she's back, notwithstanding that there's a court judgment saying she has no right to access the property, and still trying to get a building permit. So that's sort of the background. I don't have a whole lot to add in terms of the legal arguments that your counsel argued before.
Good, thank you. Do you want to say anything? No?
If I may address a few points. One area of concern that I have with respect to this deposition. Is that the deposition transcript? The attorney took you to page 8, in which he quotes, apparently, Sally Moran. in a trial, and this is not a trial, but in a trial, that would be excludable on hearsay grounds, because this person cannot testify to what she said, with rare exceptions in the trial court. So his representation to you that Sally said this is not correct. What he should have represented to you is that the deponent said that Sally said this, and then take that with a grain of salt. There's a substantial difference there. If you bear with me, I want to make sure we're looking at the same document here as well. There is also a deposition of, which I don't have copies for you here, and I apologize that I'll let you review this. If you have a photocopy here, you can make copies of it. The deposition transcript given to you by the attorney for the school is dated March 2, 2004. And it took you to page 8. There's also another deposition of Elva Smith that was taken on January 31st of 2005. Do you have that deposition transcript? And on page 7, this is Elva Smith's testimony under oath. On page 11, but I used to lie and make myself younger because I was working. So I would ask you to take that statement and then take the other statements that she makes in this deposition transcript with a grain of salt. With respect to the attorney for the code enforcement officer, she made a comment to you that I thought was very significant, and I hope you picked up on it. She said that a building permit would be granted, or should be granted, or words to that effect, if there is some claim to Bus Lane Road, which there is. There is some claim, and the claim is based on a public right-of-way, public access, and even through Ricker Lane. Fred Bouchard, and we didn't talk about this earlier, had even told Ms. Moore that if she could have access through Ricker Lane through the easement that she has now to get up to her property on the back side. There's a couple different ways that she can get access to the property, but right now she's being denied the building permit by the code enforcement officer, who has not been able to find a way to find that there's access to the property. And the reason why she denied the permit was because she relied on a court decision, as I've already said, that simply found that there was no private easement. There's a significant difference there. What's before the board today is a decision to either uphold the code enforcement officer's decision or to say that it was wrong and issue the permit. We would ask you to do that. Thank you.
As far as it has to be a public or a private right-of-way that these people would need to have.
And that's what Section 2.06 requires, and of course, in order to utilize a private right-of-way, they have to have a private right to utilize it. It can't just be a private right-of-way, it has to be one that they have a right to use.
They own it?
They have to have a right over it, they would have to have an easement or some other legal right to utilize it.
Which we have determined there are none.
The court determined that there were no private rights, that's correct.
Anywhere? River Lane or anything else?
Well, the question was the Bus Lane Road
Yeah,
Bus
with the
Lane.
court.
Yeah, the court didn't decide Ricker Lane.
I can address Ricker Lane if the planning board's interested. The zoning board.
As far as the application is concerned, we're talking about Bus Lane Road. And that's the only thing that we need.
Well, we're talking about whether they have a recorded right-of-way to their property of no less than 50 feet in width.
No, I would disagree with that assessment. It's not whether there's a recorded right-of-way of 50 feet or less. The question is whether there's access to the property that meets the code of the statutory provisions of having enough access to the property to build a home there.
Well, I don't believe you can do it over private property.
Oh, I agree.
Oh, okay. Anybody else speak? Questions?
Well, I have to go back to what Natalie said about, do we even have jurisdiction over saying if?
No, we don't.
So, okay.
No, our decision tonight is just that we agree with, or disagree with the code enforcement officer denying the permit.
Okay.
On bus lanes.
No, I would suggest that it's all encompassing. Is there access to the property?
I don't believe so, because I believe this application is referring to a bus lane and bus lane only. And if he was gonna,
I think it's
True.
off Wicker Lane. It was a bus lane or Wicker. It's an off Wicker.
And you also need to consider that the historical use of bus lane road be connected with the lane.
I mean, as far as that goes, everybody in town has used bus lane road. I'm the only person who's ever been arrested for going down to use it to go to my property, but the whole town, and everybody sitting here knows that they have used this at one point or another. The bus lane road to go down, back to either watch football. You know, people go down there, they walk their dogs, they bike, they play with their kites, and they have remote airplanes, and it's like a recreation for one.
They were deer hunting for a long time in there, we're the ones that kind of stopped it.
But I go down to my property and I get arrested for trespassing when the whole town, entire town has used that road at one point or another. It just doesn't seem quite fair.
But we can't determine whether it's a town, that it's a town road or a public way or so on. I know for a fact that it's not a town road. It's not on the list of roads.
Who maintains and plows? Plus, like the school does, doesn't it?
District does. It's really not up to us to decide whether it's a
No.
public way or access to that road. If you're asking for a building permit from Patty and using that as determining your access to your property to establish residence, then you'd have to prove a right-of-way. If not, then you've got to have a right-of-way somewhere, which you have on Ricker Lane, I believe. And whether that meets the standards that are required for a right-of-way, that's Patty, up to Patty to look.
So if I heard your comment right, you believe that they do have access through Ricker Lane?
No.
No.
No, we
I'm
don't know if
asking
they...
you, sir, to
No.
clarify.
No, I
Okay.
don't. I'm saying that they need to show that they have access either on Bus Lane or Ricker Lane, and Bus Lane, we can't determine if that's a right-of-way.
Okay, but
The Moorings say they have access.
They say they have
Right,
access
right.
through a
But I
right-of-way
think,
on
I
Ricker
think that
Lane.
what the decision here is for the board to consider is whether the code enforcement officer's denial of the permit was proper. The basis for the denial was a court judgment that found that there was no private easement. That's what you have to decide. Was the denial based on the lack of a private easement proper?
Do we have any other comments? Patty? Yeah.
If I could, Patty's been trying to, I'm not sure she's got a clear plan that shows everything, but of course, if the claim is that Ricker Lane serves as the access, one of two things has to exist. One is that there has to be 100 feet of frontage for the lot on Ricker Lane, which I don't have any evidence before me that that's actually met. Or there has to be the private access, the deeded access from their lot to Ricker Lane that has to meet those requirements in the ordinance, which I believe is 50 feet in width. And there hasn't been anything shown to the board that I've seen that shows that either of those two requirements is met as to Ricker Lane. Obviously, because the application that I saw mostly addressed bus lane, I concentrated on that. But Patty doesn't have anything in her file that supports the alternative request that there is legal access by the Ricker Lane either. And I would submit to the board that it is the applicant's burden of proof on this, as on all issues when a building permit is sought. And, let's see. There was a prior request for a variance that Patty is showing me, and that there was a variance sought because the easement didn't meet the 50-foot minimum right-of-way requirement. The land narrowed to 22 feet, and I believe that the variance was denied. So at least in 2003, there was not 50 feet for an access from Ricker Lane to the lot.
Was this brought up when they came before us before?
That's
Was
what I
what
think she's
the-
talking
When
about.
they came before the board
Was what
before?
brought up?
That was for Ricker Lane.
Right, the access for Ricker Lane.
Is that what,
What it
Was-
was I had a middle part, it was like a bottle, it was 50 feet.
right, I remember that in the
And then it
trailer.
came back, but that middle part of my land on that easement is bigger than Ricker Lane. Ricker Lane is carved to 17 3/4, and my easement's 22 and a half.
That's not the
Just the one
standard.
driveway is bigger than Ricker Lane.
And I haven't had a chance to review this fully this evening, but I would call your attention for the record, I don't know if we're, I assume we're being recorded here. Book 13610, page 188 of the York County Registry of Deeds, that does show an easement on Ricker Lane. But again, I would want to review this a little bit further, but you may want to take a look at it. If you have a photocopy, I'll leave you a photocopy here.
And that easement is bigger than Ricker Lane. And they're using a two-way traffic on Ricker Lane with 17 3/4, and I have 22 and a half feet. In the middle part that I couldn't get a variance on, which is still bigger than Ricker Lane.
Ricker Lane's over 30 feet.
That's not what they have tied, though. They only have tied
Yeah, that-
17
That
3/4.
that doesn't matter, ma'am.
But I still have
The
55.
the easement is the question, and Ricker Lane is more than 17 feet.
Travel,
I believe that easement is 35 feet. It may be 30, but
I went up and measured it. 17 3/4
those lawns down through Ricker Lane are owned by the town of Waterboro and include some of the fences.
I have a question for Patty. Their request for a building permit on this lot that you denied, where do they show their access for egress and ingress to that property?
They were
On your
planning to
plot
have it
plan.
over the Bus Lane Road, and because of this ZBA ruling on
Right. 2003.
2003, where we had talked about the Ricker Lane access, that wasn't in question, I mean, that wasn't reviewed by me at this time as even being a possibility for access.
Is it, that
Their
was
plot
denied.
plan, did their plot plan show any specific driveway entrances or anything like that? Where did it show for that?
I'm not even sure we got that far, but
Those are, what, wasn't it like the land got real close and there was a trailer or something like that? Yeah, and it was, there wasn't enough land.
Well, what it was denied for was character of the road. That's what you guys denied it on, was character of the road.
No,
saying that
no.
too much well, that's what.
No, not on this board. Might have been on a different board, but not on this one.
I was on the variance somewhere.
it was denied because it was ruled that the 50-foot right-of-way has to be 50 feet all the
Right.
way to the property, and it narrows down, and that's
Right.
why it was denied,
Yeah, I
according to
remember,
this.
something to do with the trailer. and- yeah.
It isn't clear where they're claiming access on this site plan at all.
Other than the application is saying bus lane, right? Yeah.
And they're not saying where, right? They're just saying anywhere on that?
Any other comments? We'll close the public portion of this meeting. Is there any discussion from the board? The question is simply, does Patty have the authority to deny this permit with the information that we have? What do you say? Nothing?
Quiet today.
I guess so. There are no more questions. I'd like to hear a motion. You going to make a motion? I'll make the motion. Huh?
You ready to go?
You make a motion.
Huh?
Someone's got to make a
Someone's
motion.
making-
Yeah. Go ahead.
Go ahead, Beth.
I make a motion that we deny the applicant's request. I think Patty was in the right, and until this person can show where and how.
Okay. I'll second that.
I can say I'll second, I don't mind seconding.
All those in favor of the motion? Motion is carried. 6-0.
If I can ask for a clarification that the motion was to deny, is that based on, that they have the burden of showing that there is access somewhere? Is that
Yes.
what your basis is?
Yes,
Yes.
That's correct.
and yes. And
I just want to make sure that I
Yes.
understand it right, which I think I do.
Yes, that's, I made my, base my motion on is that.
Thank you.
At this time, we need to advise the applicants, if you are unhappy with this decision, you may request reconsideration by the board within 10 days of this decision. The parties may appeal this decision to Superior Court within 45 days from the date of your notice.
Does a request for reconsideration stay the 45 days to the Superior Court? Or do you know?
Could I answer that, since I do know? A request for reconsideration has to be done in accordance with the Board of Appeals statute 2691, and it will only serve to delay the 45-day appeal period if, in fact, the board votes to reconsider. If the board has a request for reconsideration but doesn't vote to reconsider, then the 45 days continues to run. And it only is extended if they do vote to reconsider for an additional, I can't remember if it's 10 or 15 days beyond the date of their final vote. So I suggest you look at 2691 and it will tell you how that works.
Meeting closed.